Hello, everyone, and welcome. Thank you all for joining Foley and Lardner for today's presentation, Non-Competes Under Attack. Biden administration seeks to limit restrictive covenants in the United States. And now I will turn it over to Don Schrader.
Hey, thanks a lot. This is Don Schroeder, partner in the Labor and Employment Group in Foley and Lardner's Boston office. And along with me today is my cohort, Ben Dryden, who is a partner in the antitrust group of Foley and Lardner down in the DC office. And we're going to try to have a pretty interactive session, even though we're obviously doing this by teams. And we're going to go back and forth between Ben and myself. The agenda, as you'll see, is a couple of topics. Overview of President Biden's executive order. How did we get here? The FTC's Rulemaking Authority, and then what's next? What do we think will happen down the line? I think the good thing is we don't think anything's going to happen tomorrow, but things are certainly afoot, and we'll give you at least some of our prognostications on what's likely to happen. And without further ado, let me turn it over to Ben.
Great. Thank you, Don. And thank you, everyone, for joining today. I'm Ben Dryden. There's a lot to cover, and so we'll just start with the headline, which was on July 9th, President Biden signed an executive order on promoting competition in the American economy, which does a number of things, including adopting a quote-unquote whole of government effort to promote competition in the American economy. There were a number of items in the executive order, 72 different itemized initiatives that implicate more than a dozen federal agencies. But one of the big headlines was a call on the Federal Trade Commission to consider adopting a regulation that would curtail the use of employee non-compete agreements, which will be the focus of today. But I mean, that was one of 72 initiatives. I should say it wasn't just one of 72 things. It wasn't just buried in there. It was one of the headline initiatives in the executive order. But among other things, this executive order broadly called on the two federal antitrust enforcement agencies, which are the Federal Trade Commission and the Department of Justice, to step up their antitrust enforcement, and to do so particularly with a focus on the labor market, agricultural markets, healthcare markets, and the technology sector. So with respect to labor markets, which is what we're going to be focusing on today, the executive order has three specific directives. And again, this is 3 out of 72, but they were featured pretty prominently. That this is, a large part of the focus of the executive order. The 3 specific labor-related directives in the executive orders. First, as I mentioned, the Federal Trade Commission is encouraged to consider adopting regulations that would curtail or ban the use of employee non-compete agreements. And that's really what the focus of what we're going to be discussing today. There were 2 other labor market driven directives in the executive order. One is that the Federal Trade Commission is encouraged to consider adopting regulations against unfair occupational licensing restrictions. For example, state or federal laws that require a license to do a job. This one's a real wild card. I don't really know where the government intends to go with this, and it's very unclear, as we'll get into in this presentation, if the FTC even has the authority to, preempt state licensing laws. But they're going to explore their authority and see what can be done. I mean, the gravamen of what they're trying to address is they're trying to make it easier for employees to go from one employer to another. And one particular situation that has been identified as spouses of military members. If your spouse is in the military, you could be sent from state to state to state, year after year after year. You're constantly moving and needing to find new employment. And to the extent there are license requirements at the state level, it can be very difficult for military spouses to go from one state to another state. And so that's one specific issue that the executive order is meant to address. But how that's going to shake out is a big wild card. The last directive that relates to labor markets is We'll talk about this in a little more detail, but the FTC and the DOJ are both encouraged to consider revising past guidance that relates to the sharing of employee wage and benefit information to prevent collusion among competing employers. We'll talk about, what it is they seem to have in mind in a little bit, but those are the three specific directives. As Don said, nothing has changed immediately. The executive order isn't itself a law and it isn't itself a regulation. It's calling on the agencies to consider adopting regulations, but things can move pretty quickly. And so we're going to talk about where this is headed. Now, I said there were 72 other initiatives in this executive order. We just discussed 3 of them. I won't even begin to explore the others in any detail, but it was an executive order on the promotion of competition. So in broad strokes, the agency really is, or the administration really is articulating that it is its policy to vigorously enforce the antitrust laws. And one big implication of that is they are going to increase scrutiny of mergers. That there are guidelines that the DOJ and the FTC adopt or recognize on mergers, the horizontal merger guidelines, the vertical merger guidelines. The executive order calls on the agencies to take another look at those and see whether they can be strengthened. Another provision in the executive order is bringing back the Obama era's net neutrality rules, which, to oversimplify, require internet service providers to treat all internet traffic and all internet users as equal. And then there's a lot of really specific things. There's right to repair tractors and right to repair broken iPhones and adopting regulations that would allow the over-the-counter sales of hearing aids. There's a lot of things in this executive order, but the directives that relate to labor markets really are a large focus of the executive order. So we will turn to that next. Now, so much of antitrust law is history, and we're in this bizarre moment where antitrust law is being applied to labor markets, and that's not something that has happened very often. And so I think it's worth taking a couple minutes to take a couple steps back and just ask, how is it that we got here? What has led to this moment where antitrust law is being applied to labor and employment? In the interest of starting somewhere, I'll start 11 years ago, where the Department of Justice brought a large civil complaint against a number of big tech companies. And there's a lot of stories in the news about antitrust issues in big tech companies. This was really the first case since the Microsoft case in the 1990s. This is the first time that the DOJ really was using the antitrust laws to go after this next wave of tech companies, the Apples of the world, the Googles of the world. And the case they brought involved labor and employment. The allegation of the case was that a number of big tech companies in California, I mentioned Apple and Google, but also companies like Adobe and Intel and Pixar even, all had an agreement among themselves, allegedly, not to cold call one another's employees. And it's important to think of the context. These are big tech companies in California where, as many people on the phone or on this call know, non-compete agreements aren't enforceable in the state of California. So these companies weren't able to bind their employees to non-compete agreements. So instead of doing that, they just had an agreement among themselves that they wouldn't poach one another's employees. They wouldn't cold call. And you're thinking, really high-end software engineers, people like that who have a very particular set of skills and were very much in demand in Silicon Valley. So the DOJ sued these companies with an allegation that this was an agreement among competing employers. And what's interesting is, Apple doesn't necessarily compete with Adobe or with Pixar, and Google doesn't necessarily compete with Intel or Intuit, but they're not competitors in the sense that they sell different products. Even back then, Apple and Google were just starting to get into mobile phones. But they were competitors in the market for talent, for employing these really high-end, sophisticated software engineers. So the DOJ was saying this was an agreement, a collusive agreement among competing employers not to compete with each other for talent. And they said that was a violation of the Sherman Act. And they brought a civil lawsuit, and they settled it, just basically with a consent decree. The companies agreed they wouldn't do it anymore. But immediately thereafter, private class action lawsuits followed, which settled for a collective, more than $400 million. So this is a really big antitrust case. That was 11 years ago. Jump forward to 5 years ago, 2016. This was just a couple weeks before the 2016 presidential election. Largely out of the blue, the Department of Justice and Federal Trade Commission released what they called antitrust guidance for human resource professionals that, in the main, alerted the HR community that agreements like they saw with the big tech no poach case, agreements where companies are agreeing not to poach one another's employees, will, in appropriate cases, be prosecuted criminally, subject to the Department of Justice's exercise of prosecutorial discretion. So this was them throwing down the gauntlet, saying if we keep on seeing things like this, we reserve the right to bring criminal charges. And they didn't just include no poach agreements where companies agree not to cold call or poach employees, but they also included what they called wage fixing. If two companies agreed, we're not going to pay employees more than minimum wage, they said, if we see that in an appropriate case, we'll prosecute that criminally. This HR guidance, and it's a short document, it's 11 pages. It also has a couple pages about exercising caution in wage and benefit surveys. And it was these couple pages that were implicated by the executive order. But in the wake of this 2016 guidance, the DOJ, in fact, has brought 4 criminal cases alleging criminal no poach or wage fixing conduct. The most recent of these cases was brought just last week. Now, interestingly, it took a little time for these cases to percolate. So all 4 of these cases have been brought in the past 8 months, since December. And coincidentally or not, they're all in the healthcare sector. But there's 3 cases listed. One of them is 2 parts. There was a company in Texas that was indicted, and then a company in Colorado that was indicted last week. They're all alleged agreements either to fix wages or not to poach employees, and it spans relatively low-level employees all the way up to senior-level executives that were at issue in these criminal prosecutions. So this was the first big step in what I'd call the anti-trustification of labor and employment law. To touch again on the wage and benefit surveys guidance. So the HR guidance said, if 2 companies get together in a smoke-filled room and exchange information about what they're paying employees, that's a bad look. But that doesn't mean that every time 2 companies exchange information about what wages or benefits they're paying, it doesn't mean that's necessarily unlawful. And in fact, it went further and said, an information exchange about wages and benefits may in fact be lawful. And it set forth a number of factors. So if there's a neutral third party, compiling the information, whether it's a consultant or a trade association or something like that, if it's a neutral third party managing the exchange, the information, I'm picturing a wage survey. If the information is all relatively old, as a rule of thumb, maybe 3 months old is a good guidepost. And if any information that's then shared out to the business community is aggregated so that you can't, reverse engineer any one employer's wages, then an information exchange like that really might be lawful. And in fact, there's guidance going back to 1996 in the healthcare industry that says not only might an information exchange like this be lawful, this really might be pro-competitive. An employer can use information like this to better determine what wages it should be offering to employees. And in fact, it could result in employees taking, higher wages than they otherwise would. So an information exchange is perfectly lawful and often pro-competitive. So coming back to the executive order from a couple weeks ago, it's not entirely clear why the president wants the agencies to revisit this guidance, but there's a hint in a press release the White House issued. The hint is that workers might be harmed by existing guidance that allows third parties to make wage data available to employers and not to workers. in certain circumstances. So perhaps they're going to adopt a rule requiring wage surveys to be shared with employees. That's speculation, but otherwise, I really don't know what the concern with this guidance is, because it's pretty middle of the road guidance. Anyway, continuing with the antitrustification of labor and employment law, in the wake of this 2016 guidance, suddenly there was refreshed attention on whether the antitrust laws can be used to protect workers. And I said there's two federal antitrust enforcement agencies, the Federal Trade Commission and the DOJ. The antitrust laws can also be enforced by state attorneys general. And so in the wake of the 2016 guidance, state AGs really took up the mantle and started pushing the envelope on applying the antitrust laws to protect workers. And very notably, the Attorney General of Washington State, Bob Ferguson, and it was a number of other attorneys general, challenged the use of no poach agreements within national franchise chains. So one of the notable examples was McDonald's. McDonald's Corporation, big corporation, then has thousands of independent franchisees. In those franchise agreements, there was a clause that said that one franchise wouldn't poach or hire employees from another franchise. And the rationale was, if all the McDonald's franchises are infighting for employees, then that hurts the McDonald's brand, that hurts them as a chain. And, making sure everyone's rowing in the same direction helps McDonald's as an organization compete with the likes of Burger King, compete with the likes of Wendy's. So there was a plausible rationale for that provision, and it wasn't just McDonald's. I don't mean to single them out at all. It was just an example. There were more than 200 companies that were investigated, and largely to avoid just the bad publicity, these companies just kind of said, that's fine, we'll abandon these provisions. And so it was more than 200 companies involving nearly 200,000 franchise locations from coast to coast broadly decided to no longer enforce these no poach provisions. And it was a really big moment in the antitrustification of labor and employment law. And what's notable, I'm an antitrust lawyer. There's a big distinction in antitrust law between horizontal agreements and vertical agreements. Horizontal is an agreement between competitors. Vertical is an agreement between two companies in different levels of distribution. These franchise agreements were vertical agreements, not horizontal agreements. And antitrust law traditionally regulates vertical agreements much more leniently than horizontal ones. So it was a very aggressive application of the laws. But it got a lot of publicity, and it was good politics. And what followed were calls on Capitol Hill to just adopt federal legislation that bans the use of non-competes in any circumstance, not just limited to franchises. So Senators Christopher Murray and Elizabeth Warren proposed a bill that basically would have banned non-competes across the board. That bill still would have permitted NDAs, or it would have permitted NDAs to the extent they protect trade secrets. And notably, even a Republican, Marco Rubio, has proposed similar legislation. He has more exemptions. You could have a non-compete provision for an exempt employee, an employee who's exempt from overtime laws. And he also would have allowed NDAs that protect trade secrets. But there was this momentum for doing something at the federal level, and Joe Biden got involved. And in 2018, he was a private citizen. He wasn't yet a formal candidate for president. He gave a keynote address at the Brookings Institution on the future of the middle class, and he identified non-compete clauses as one of the factors that, in his view, were really restraining middle-class growth. And he gave this quote. It was one of these laugh lines that 40% of all the workers in the United States will, during their careers, have to sign a non-compete clause. Sandwich makers, not a joke, sandwich makers. And he got a laugh. And over time, that same line has been repeated. And he in fact, in his remarks when signing the executive order 2 weeks ago, mentioned McDonald's. He mentioned the McDonald's example, but he got his facts wrong. He was thinking of the franchise agreements, but he said that McDonald's was telling line employees that they can't go work at Burger King. But that's not what McDonald's ever did. But he's repeated that line a few times, both on the campaign trail and then as president last week. So some fact-checking organizations have identified that as not entirely accurate, but that's where they're coming from. So this is all the antitrustification of labor and employment law. At the same time, things have also happened on a local level. With that, I'm going to pass the baton back to Don.
Hey, thanks, Ben. A couple things. What's interesting is we use phrases like cold calling and wage and benefit surveys, and I think in some ways those are vestiges of pre-2000, because I'm not sure anybody calls anybody anymore. At least in my family, everything's by text with my 3 teenage kids. Perhaps it's just me. And also just on wage and benefit surveys, as everybody knows, everything's available on the internet now. So it's going to be hard, I think, to enforce those provisions in that regard. And I think they're going to have to pivot in light of what's going on with Google and the internet. Now, in terms of where we are, and Ben's right, 2016, you had the DOJ FTC guidance. Very few people were worried about it. Very few people were concerned about it. Every once in a while, somebody would bring it up in the context of litigation as to why something couldn't be settled in terms of some form of restriction, that somehow that would be a no poaching rule and that the FTC would have a problem. And really what they're focusing on now, it seems, are just blatant, egregious efforts at having private industry agreements on their own to not poach each other's employees. We'll see where those cases go. It's taken a couple of years for them to even get to this point, and the guidance is now 5 years old. In terms of state legislation, there's a couple of states that are listed here: Illinois, Oregon, Nevada, Massachusetts, and DC. And I will tell you that Oregon had a statute on the books, and maybe we'll start with Illinois first. If you go to that slide, so all of these laws that are on the books kind of focus on the non-exempt category, the under a certain salary threshold category, and then also try to limit the scope and duration of non-competes. Having litigated non-competes up and down the Eastern Seaboard and a few states in the Midwest as well, I can tell you, obviously, each state is different. Very few states have statutes on the books. Obviously, California has the one that says no non-competes ever. And now you're starting to see other states that have different requirements, not wholesale bans per se, although DC, that is the point of their law. Here, it's the income threshold of 75,000. You got to have adequate consideration. And they've got to have some time to look at it ahead of time before they execute it, and a required time period. And that's where a lot of these state statutes are going. Oregon, for example, they had a statute on the books that was 18 months. And now this was just signed, and all these things are fairly recent. May 21, 2021, the governor signed a Senate bill that said, all right, no non-competes for anything beyond 12 months, null and void otherwise. The income threshold for non-competes was $100,533. Don't ask me how or why they decided to latch on to that specific dollar amount, but that's what the law is. And it makes non-competes void and unenforceable when all of the statutory requirements aren't satisfied. This law, it will go into effect. It will basically invalidate any non-competes that are entered into after January 1, 2022. In addition, you've got Nevada. Nevada, like Massachusetts, although it relates to non-exempts, Nevada, it has restrictions about not applying to anybody with an hourly wage. And if the non-compete does apply to somebody with an hourly wage, that employee is entitled to reasonable attorney's fees and costs. So there's a bit of a significant draconian penalty if somebody tries to do that. And so obviously everybody needs to be mindful of that. Massachusetts, I call it the mini-me of California, because it's always not too far behind California in terms of employee rights. And so you need to be mindful of the fact that there are a couple things here. One, if you're going to have a non-compete, you got to have adequate consideration. So there used to be a series of cases that stood for the proposition that you could have a non-compete even if it's entered into after the start of employment. But continued employment is not going to be enough anymore. You've got to show that you have a legitimate business reason, like trade secret, confidential information, customer goodwill, a legitimate business interest that needs to be protected. And here's where things get really more difficult and for employers. You can have a 1-year non-compete, up to 1 year. There are very limited circumstances where it can be 2 years, and that's really where somebody did something really bad. And just as a side note, while we're on the topic of Massachusetts, and really it doesn't matter what state we're dealing with, I will tell you from almost 30 years of doing these cases, what a court will look at. So we could talk about the laws and the specific provisions. What the court starts out with, and it doesn't matter whether you're in state or federal court, doesn't matter whether you're in Kentucky or North Carolina, Virginia, Maryland, or New Jersey, my home state, you need to know that the court will first look to see who is the bad guy, who did something wrong. Did the employer engage in overly aggressive pursuit of restrictive covenants towards an employee, or did the employee leave with the secret sauce and a few other things along the way? And that will be the lens through which that case will be viewed. So all these things are really important, but be mindful of making sure that you, as the employer, either the new employer or the old employer, that you are always taking the high road. Couple of things that you should also be mindful of. A number of employers think, well, we could just work around it. We'll just use another state's law to apply. Well, Massachusetts does not allow you to do that. If the person lives and works here, you got to apply Massachusetts law. And so you need to know that. And there are certain categories, though, of people that cannot have a non-compete. Non-exempt people, meaning anybody overtime eligible. Undergrads or grad students who are not working full-time. Anybody who's terminated without cause, unless they sign a separation agreement. And in that context, they could be on the hook for it. And so you just need to understand that at the end of the day, you are going to have certain restrictions in certain states that will impact your ability to do things. Now, this does not prevent you, and if we got, not sure if we have one more state there, Washington, D.C. This is the one that really puts a total ban on non-compete agreements. And some exceptions for licensed physicians, prohibits any workplace policies prohibiting employees from moonlighting with another employer while they're employed, and also an anti-retaliation provision relating to a refusal to sign a non-compete. Now, this act hasn't gone into effect as of yet, and we'll wait and see when that actually happens. But this seems to be one of the few cases like California where there's a total ban. Now, this does not prevent, though, I mean, before I turn to one of my other favorite subjects, legislation, this does not prevent an employer from having a non-solicitation provision on steroids. You could always do that. And you should think about, what do you want to do? Do you want to have just a very robust non-solicitation provision which allows you to circumvent having to deal with a number of these restrictions in a lot of different states? Many employers who have multi-state outposts and facilities have decided to go that route because it's much easier to defend. It is narrowly tailored, and it allows you to use a uniform agreement. Now, what else is Biden looking at right now? Well, obviously, the Biden administration received major endorsements from the labor movement. The current Secretary of Labor is the former mayor of Boston, but he was the head of a union before that in Boston and had major ties to the union movement. And so what you're going to see is this effort by, I think, the new administration to tie in the non-compete issue as a result of pressure from the labor movement, in part to basically have a different landscape going forward. With that, I'm going to turn back to Ben, but we'll share the screen back and forth, so to speak, although he's in charge of the PowerPoint, thank God. Thanks, Ben.
Okay. So with all these calls and all this momentum into increasing employer mobility and bringing antitrust scrutiny to labor practices, last year, in January of last year, the FTC held a workshop with the stated purpose of examining whether there's a sufficient legal basis and empirical economic support to justify the FTC adopting a rule that would restrict the use of non-compete clauses in employer-employee employment contracts. So there's a full-day public workshop, and the materials are available online. You can listen to it or read the transcript. But they brought in experts who spoke, I would say, primarily about the empirical economic question. I mean, there were people who came in and said, cited all sorts of findings that they believe that employee non-competes are restraining wages and creating abuses, and it's not hard to imagine circumstances where there might be merit to that, but no one ever came in and said that employee non-competes are always pernicious. And there was some evidence that there's some cases that physicians, they said, and I noted that one of the states excluded physicians from, DC excluded physicians from the scope of non-compete law. Physicians who are subject to non-competes tend to make more money than physicians who aren't subject to non-competes. That's just the empirical finding. So the FTC held this hearing. There was some discussion of whether they have the legal authority to adopt a rule. I should say this isn't something they often adopt rules into. We'll get into that in a little bit. But they invited the public to submit comments after the meeting. The comments were due March 11th, 2020. And so by then, the pandemic had taken over everyone's attention. So everyone was just trying to get through the day. And then, there was the summer and the election, the presidential transition. So nothing really happened until the executive order last week. But the FTC did have this on the table since last year, since their workshop last year. So with that, we're going to explore the FTC's rulemaking authority. I'll try to stay too far out of the weeds on this, but it's a really interesting legal question, kind of where this is heading. Does the FTC even have the power to do this? So just first things first, what is the FTC? The FTC is a 5-member commission. There's 5 individual commissioners, each of whom is nominated by the president or appointed by the president and confirmed by the Senate. 5 commissioners, no more than 3 can be from the same political party. So, there were 5 commissioners under Trump, 3 Republicans, 2 Democrats. That's now flipping. The FTC has 2 real charges. One is to protect consumers, which it does by going after deceptive trade practices, and it's more and more becoming a privacy regulator, and that's all under its consumer protection mandate. Its other mandate, which goes hand in hand with protecting consumers, but it's promoting competition. And so the FTC has the power to enforce the antitrust laws, which are a body of laws that broadly serve to promote free and fair competition. But the FTC's authority is broader than the antitrust laws. Anything that, or I should say, the FTC Act speaks in terms of prohibiting unfair methods of competition. And the Supreme Court has said anything that violates the antitrust laws, by definition, is an unfair method of competition. But there are other things that do not violate the antitrust laws that can still be unfair methods of competition. So the FTC's competition authority goes broader than just enforcing the antitrust laws. But as a practical matter, the FTC's been, at least in the past 4 decades, has been pretty consistent with applying the antitrust laws and maybe filling individual gaps in the antitrust laws. And one example is it's illegal to price fix, but it's not squarely illegal to suggest to a competitor that you engage in price fixing if your competitor then refuses a suggestion. But if they call that an invitation to collude case, the FTC will say, okay, an invitation to collude, even though it's not technically prohibited by the antitrust laws, that's an unfair method of competition. So that's the type of thing that over the past 4 decades or so, they have used their unfair acts power to go after. And they've acted on a case-by-case basis, really consistent with the common law tradition of every case is different. And these cases are decided either by federal courts or the FTC has an in-house administrative law judge. They currently just have one judge, but the judge really is a neutral arbiter, and he's employed by the commission, but he really does hold the commission accountable to proving their enforcement cases. So that's who the FTC is. I said they historically have brought cases on a case-by-case basis, but there have been increasing calls over the past few years to see whether the FTC has more powers, whether it can act as a regulatory agency to adopt substantive rules that define what an unfair method of competition is. And there have been several articles put out by the Democratic commissioners over the past few years. I say the most notable is the one that I've excerpted here, which came out last year, was published in the University of Chicago Law Review, and it was written by Commissioner Rohit Chopra and his former attorney advisor, Lena Khan. And they argued that the FTC does, in fact, have the power to adopt substantive rules that put some flesh on what it means to constitute an unfair method of competition, and to do so more broadly than just on a case-by-case, party-by-party basis. And there are a couple different procedures that the commissioners have pointed to as giving them what they claim to be this rulemaking authority. And it's not clear which path they would take pursuant to the president's executive order. And I should pause and just say, this is not something that they have done for a very, very long time. So we are very much in a brave new world where the FTC is going to be testing out its authority, and private parties are probably going to be testing that with them. So here are the two paths. The first path, and this is the one that I think is the more likely path for the FTC to take pursuant to the president's executive order, is just traditional rulemaking pursuant to the Administrative Procedures Act. The statutory authority here is the FTC has statutory authority to make rules and regulations for the purpose of carrying out the prohibition on unfair methods of competition. And you have to go back 48 years, but 48 years ago, there was a litigated case where the DC Circuit Court of Appeals said that this statutory authority not only gives the FTC the power to adopt rules of procedure, how procedurally they'll go about stopping unfair methods of competition, but according to the DC Circuit 48 years ago, the FTC also has the authority to issue binding substantive rules. Now, the rule that was at issue in that case was a very narrow rule about posting octane rating numbers on gasoline pumps. And if you don't post your octane number, that's an unfair method of competition. Nothing along the lines of broadly prohibiting a practice like having employee non-competes that are firmly allowed under many states' laws. So it'd be a very, very different rulemaking practice than the FTC has ever done before. But that's where this authority would come from. The Administrative Procedures Act has some simple requirements. These are the requirements that have to be followed whenever a regulation is adopted. They include the agency has to issue notice of the proposed rule. They have to cite their authority to adopt the rule. They have to say the date that the rule is going to go into effect, which must be at least 30 days after the issuance of the notice. There's also an opportunity for the public to submit comments. So, if the FTC takes this path to adopt rules pursuant to the executive order, the public has the right to submit substantive comments and to make arguments and to submit data. And the agency then has to address every single comment and think about every comment. It doesn't have to agree with the comment. It can say, well, we hear you, we just disagree, but they have to go through the process. And if they don't go through the process, then that's grounds to challenge the regulation after the fact. Now, what's interesting about this, I said it was 48 years ago, the DC Circuit recognized this power. Shortly thereafter, Congress limited this power, and they adopted, and it happened over the course of several years and amendments, but they adopted what's called the MagnusMoss Warranty Act, which is the second path for the FTC to adopt regulations. And the idea was that the FTC in the 70s had a moment where it really was exerting a lot of power, and there were calls that it was becoming a nanny agency, and critics called it the second most powerful legislature in Washington. So Congress, to curb the power of the FTC, adopted an even more onerous procedure for adopting regulations, the MagnusMoss Warranty Act. And the MagnusMoss Act involves two different layers of notice and comment, and giving notice to congressional oversight committees, and then having an opportunity for a hearing, an informal hearing to present your data. So it's not just if the public wants to submit comments against a rule that they can submit the comments, and that's kind of the end of it. No, there's an opportunity to actually appear and present evidence and be heard in person. So Congress adopted the MagnusMoss procedures. The FTC, this gets you to the Reagan administration. They then went even further and said, the FTC should not be the nanny agency. So the FTC adopted additional regulations that even increased the burden of going through the MagnusMoss rulemaking process. And the result was the FTC just kind of forgot that it had this rulemaking power. It really hasn't been exercised for decades. And until a few weeks ago, there were these additional procedures in place that really made rulemaking impracticable, but the commission has since rescinded those. But to get back to the commission, so under Trump, there were 3 Republican commissioners, 2 Democratic commissioners. After the presidential transition, the FTC chair appointed by Trump resigned, and that left a 2-2 political tie. And so President Biden named Democratic Commissioner Rebecca Slaughter the acting FTC chair, and one of her first actions was creating a rulemaking group lodged within the FTC's Office of General Counsel, charged with exploring all the possibilities for reviving this rulemaking power. And so they've been working on that for the past several months, while it was a 2-2 political tie. Well, in the meantime, President Biden nominated Lina Khan, who was Commissioner Chopra's co-author in the University of Chicago essay, to fill the 5th FTC seat. And Lina Khan's kind of a cult celebrity. She first came to national prominence when she was a law student, and she wrote a very long, very thoughtful article about bringing a new antitrust lens to examining Amazon. And so she was famous for that. She got written up in the New York Times. She's kind of become a cult hero for that article. And she's done other things. She worked for the House Judiciary Committee and was the principal author of their big paper on antitrust reforms to rein in big tech. So Biden nominated her to be the 5th commissioner. She sailed through. She had bipartisan support. And so the Senate confirmed her on June 15th. And then about an hour later, in a surprise move, Biden named her the new chair of the FTC. Now, to be a commissioner, you need Senate approval. But once you're approved to be a commissioner, the president can name anyone to be the chair. So there wasn't a separate process to make her the chair. So kind of in a surprise move, and there were some claims that it was a bait and switch. She's the new chair of the FTC. She's the youngest commissioner, to say nothing of chair in FTC history. She's 32 years old, and she is a force to be reckoned with. She is a woman of action, and so she came in and just was immediately it sent the message, new sheriff in town, and she immediately adopted rules that the commission, when it meets once a month. Historically, they always meet in private, and they could have full and frank conversations with themselves and with the FTC staff, really examining the scope of their jurisdiction and examining whether their actions might have unintended consequences, really have full and frank deliberations. Chair Khan came in and said, no, going forward, all commission meetings are open. They'll be anyone who wants to attend can attend. They're going to be available on online streaming in real time. She allowed members of the public who register in advance to address the full commission and to just say what's on their minds for 60 seconds. So it was a really big reform. But then in their very first meeting, they took a few discrete steps. One was they voted to streamline the Magnuson-Moss procedure. So it's now a little bit easier. Those self-imposed restrictions on adopting rules under the Magnuson-Moss path, those are no longer in place. They also, changed rules. Like it used to be you needed a vote of the commission to issue a civil investigative demand, which is a civil subpoena. They said, no, now you just need one commissioner to sign off. So, and they rescinded a policy statement that's only 6 years old on what it means to be unfair, where the FTC 6 years ago said, and this was under Obama, said, we'll only bring unfairness cases really when there's some when we're doing something that serves the purposes of the antitrust laws. We're really, as a matter of policy, just trying to fill gaps in the antitrust laws. That policy statement has been rescinded. So they now just have no self-imposed limits on how they can apply their unfairness authority. So I don't want to put too much stock in just what one person's personality, but the chair of the commission really sets the tone on down, and the staff take leadership from her. So this really is a major change to the Federal Trade Commission. So she's now the commissioner and the chair of the commission, and the Democrats have 3 commissioners. So
what's next? So we're going to try to keep this power hour to what we said we would, and where are we going at this point? So the executive order is very broad. One of the questions I saw in our chat room was, are the executive order or any of the recent state statutes, including customer non-solicitation agreements? In fact, they don't. You can, in fact, even under the California statute, very limited circumstances where confidential proprietary information is used, you can have a form of non-solicit. It's very narrow. However, all the other state statutes really don't go into the issue of non-solicitation provisions per se. And, once again, it comes down to having a legitimate business interest. And so what I've certainly advised clients, to the extent that they are considering just a non-solicitation provision, is just making it so robust that it covers so many things that, one, you don't have to worry about non-compete statutes that may restrict what you can and can't do, but 2, you're covering almost everything anyway. So that's still fair game. I would not be surprised if you see revisions to the 2016 FTC DOJ guidance that was issued. Everybody knew about it in the employment world. I don't know that any of us really thought it had much in terms of teeth, because there were no cases brought really that mirrored the admonitions in it. So it'll be interesting to see what happens next. Obviously, there'll be notice and comment, and so there'll be a couple months of that. To the extent that there's any delays going forward, you should understand that none of this stuff is going to happen this summer. Or anytime in the next month or 2. Is it expected that the FTC will try to move quickly? Absolutely. I think they're going to try to flex their muscles on some of these points. The executive order doesn't really give them any instruction on exactly what to do or say. Do I think that something will come of that? Of course, I do think something will come of that. I think it'll just be some form of limits on the categories of employees that may be subjected to non-competes. I don't see the FTC trying to enact a full-on ban on non-competes throughout the United States. I think the objection to that would be significant and tied up in the courts for an extremely long time. As far as challenges and defenses, we've gone over some of the facts that, listen, the FTC really hasn't used, to the extent it even had jurisdiction, it hasn't really even used it at all. Now, it looks like it's trying to maneuver under the Magnus-Moss Act, among other things, to streamline its procedures, but it's very likely that if they do something that is on what would be considered a super aggressive manner, the likelihood of court action challenging the jurisdiction and standing of the FTC to even enact those rules, I think, will be met with many challenges. Ben, any comments from?
There's a footnote in that University of Chicago article where it's a telling footnote. They say, building a strong empirical record will help to defend against any challenge that we didn't use the proper procedures. So I think they recognize that they're in uncharted waters, or at least waters that have not been charted for 48 years. And they have a mandate from the President of the United States to do something significant, but they also are mindful that they have to go through the right processes, and they have to really make the right fact finding for whatever rule they end up adopting to stick. So it's going to be interesting to see how this plays out. I should say, kind of hand in hand with that, there are some jurisdictional questions. There's a note here that the FTC Act defines corporation, the term corporation, in a weird way that it excludes most not-for-profits. And so it's unclear if they even have the authority to adopt a rule that would reach not-for-profit corporations, like, large healthcare systems. Another statutory challenge is the FTC Act has a weird provision that, as far as I know, has never been interpreted, but it says that the FTC can't deem a practice unfair unless that practice is likely to cause substantial injury to consumers. And so it's unclear how they're going to thread that needle to use their unfairness powers to reach employee non-compete agreements. I'm not saying there's not a way that they can do it, but it really serves their ultimate interest to be methodical and to make sure that they're doing this in a way that passes the required tests. There's also constitutional issues that are likely to be litigated. I mean, as Don was explaining, this is an issue that's historically regulated by states. So does the FTC have the power without a clear mandate from Congress to preempt state law? There's separation of powers issues. Is the FTC stepping on Congress's toes? Is the FTC stepping on the court's toes? Because the courts have, for 125 years, been interpreting the antitrust laws. This would be a pretty radical departure from that. Don, anything else?
Well, I think, and just to that point, everything is controlled by state laws right now, and it depends on where you're, and also what court you're in. Are you in the Virginia state court system where things may be at a regular pace, or are you in what's considered the rocket docket of the Eastern District of Virginia, where you are going to be in court within a few days, if not a week? And so state courts are going to run the show for the foreseeable future, until and unless something of an edict comes down from the FTC. But even if it does, I certainly think there will be business associations like the Chamber of Commerce, among others, that will very likely challenge the jurisdiction for that, and therefore hold up any implementation / enforcement of those rules for the foreseeable future as well.
Yeah, I strongly agree with that. And I should say, we've got 4 minutes left. We want to, keep to an hour. But if there are questions, people should feel free to type them in the chat. We'll try to answer them in real time. Just one question's coming immediately. Is it possible that the FTC is silent on the question of non-competes and no hire agreements between clients and suppliers, but the DOJ sees the agreements as violating antitrust? That is possible. We're talking about agreements, between vertical agreements between a supplier and a services recipient. An interesting implication of the big tech cases from 11 years ago, those cases ultimately resulted in the consent decree. And the consent decree that the DOJ negotiated actually allowed those companies to continue to have no poach agreements in their supplier. They allowed them to have no poach clauses in their supplier agreements. To the extent they were reasonably enforceable and met certain requirements. I don't think it's the DOJ's position, or will be the DOJ's position, that those are always unlawful, but we'll see. We'll see. One other point I wanted to raise, I 100% agree with Don that I think some form of a business association challenge is likely, but in the intervening time, there is an argument that a knowing violation of an FTC rule subjects the violator to a $43,792 per day penalty. I would expect the FTC to take that position, that penalty takes effect. So, there might be a moment where businesses have to decide whether to risk that penalty or to go along with the business association challenges.
One of the just to jump in, Ben, one of the next questions says, is it safe to assume that none of this applies to a sale of business non-compete, one that's obviously entered into with the seller of a business as part of the acquisition? And I would say, yes, I think that's safe to assume. Even in California, and certainly in Massachusetts and all these other states, sale of a business, there's consideration for it. There are business reasons. It's a pretty salient and material point of a sale of business that the person entering into that is not going to then turn around and start the same business again, and therefore destroy customer goodwill, among other things. So I would not see this having an impact upon non-competes in the sale of business.
Yeah, I agree with that. I will add, however, that the FTC has been increasingly looking at non-competes entered into in connections with sales of business. So if you have a 2-year non-compete after selling a business, that's pretty defensible. If you have a 5-year non-compete, I would argue that that's defensible. A 10-year non-compete, the FTC has said that's not defensible. That's a position the FTC has taken. So I could see this coming under some scrutiny.
I haven't seen anything beyond 3 to 5 years in the sale of a business. And I agree with you that anything beyond 5 years would, one, I haven't seen it, but two, likely not be upheld.
I did want to touch on there's some interesting political angles here. So, Commissioner, it would take 3 commissioners to approve a rulemaking. Commissioner Chopra has been nominated to take another job. He's nominated to be the next CFPB director. So, and it's unclear if he's even going to get Senate confirmation for that job. But if he does, that would revert the FTC to a 2-2 political tie until his replacement is appointed. And then there's also, we mentioned Senator Rubio had proposed a freedom to compete law. Well, he has renewed that as recently as last week. So it's possible that Congress resolves this issue rather than the FTC. And, that could be the path that this goes as well.
Yeah, I wouldn't hold out too much hope on that, not to be negative, but I mean, growing up in Jersey, I have a very pessimistic view of the world. Anybody else got any questions that you would like us to go over? All right, well, we are actually right at the hour. Certainly to the extent I think I speak for Ben, we are certainly happy to answer any questions after the fact. Everybody's got our contact info, happy to go over anything offline, and we appreciate, as always, the opportunity to reach out to our clients and potential clients and friends to give some insight into what we think is coming down the pike.
Thank you all.